Hi, I'm Alec from Mr. McCall's 7B AP US Government class.
Hi, I'm Garrett.
We're going to be discussing with you the Supreme Court case Loving versus Virginia regarding interracial marriage.
Did you know?
Hi, I'm Alec.
Hi, I'm Garrett.
In the case of Loving versus Virginia, Loving was ultimately combating the state of Virginia, in which the state of Virginia said that the Loving couple ultimately was not allowed to marry as one was white and one was black. The law was strictly against interracial marriage, which ultimately fell in line to a constitutional question that regarded primarily the 14th Amendment.
And now, we present to you a dramatization of the events that led to the Supreme Court case Loving versus Virginia, with Nick Doria as Mildred Loving, Alec as Richard Loving, and Sterling as the state of Virginia.
No.
To find out more information, we polled 13 different people on Instagram, and we found that 11 people responded to the question saying yes, interracial marriage should be legal, whereas 2, for some reason, said no. That led to an 85% to 15% difference.
Now, there are two issues with this poll. One, because of the platform we used for voting, the people we polled was not representative of the population. This obviously swayed the poll to have a much younger representation than the population of the United States, and because of that, could have shifted the poll liberally. 2. We cannot know for certain if everyone took the poll seriously. Because of the limited size of the poll, only a single person wanting to make a joke could vastly sway the results. Because of these two issues, we gave the poll a 10% margin of error.
By the time of Loving versus Virginia, the question of racial issues and additionally civil rights was a hot, debated issue. So when it came down to the question of should interracial marriage be allowed, should it be legal, especially in the specific case of Loving versus Virginia, it ultimately fell in line with a large line of different civil rights issues and civil rights legislation. One great example, as most of you know, would be Brown versus Board of Education in 1954. Now, when it comes down to the question of why people should actually get out and vote, we can see that by the time of Loving versus Virginia, there was a large amount of public push both through civil rights movements, additionally through legislation being passed, those pushing for minorities to ultimately see more recognition, additionally receive more civil rights. So we can see that ultimately by voting and engaging in forms of civil rights activism, civil rights movements, and different forms of political action, especially through civic action, it's very evident that Loving versus Virginia was more than likely influenced by these different forms of voting. In the case of Plessy versus Ferguson, of course the court could never actually vote in favor of Plessy, as ultimately that would have gone against the majority opinion throughout the United States. While Supreme Court justices are supposed to have an objective view of the Constitution, it's quite evident in the case of Plessy versus Ferguson that it was simply not in line with the Constitution and simply biased, or fundamentally influenced by that of general public opinion. So in the case of Loving versus Virginia, as in with Brown versus Board of Education, it seems quite evident that they may have ultimately been influenced by the public majority, which is oftentimes seen by voting.
Now, one issue that needs to be addressed with all Supreme Court cases, especially with some regarding civil rights, is the need for a balance between public order and civil liberties. This need for balance is something that extends the importance of public opinion and its role on Supreme Court decisions. It's possible that even if the Supreme Court was on Loving's side, that they would simply not have ruled the way they did if, using data from the elections, they saw that public opinion was against this idea, something that was very possible if believers in civil rights didn't vote.
Chief Justice Earl Warren wrote for the majority, "The freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. To deny this fundamental freedom on so unsupportable a basis as the racial classifications embodying these statutes, classifications so directly subversive of the principle of equality at the heart of the 14th Amendment, is surely to deprive all the state citizens of liberty without due process of law." He continues, "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." I hope you enjoyed our video on Loving versus Virginia. It was a very important landmark case in which it was determined that interracial marriage was in fact constitutional, and any law, such as in Virginia, violating it was a violation of the Constitution. After all, it was a 9-0 decision. Thank God Clarence Thomas wasn't on the court. So make sure you go out and vote, because every single one of your votes influences the Supreme Court.
Or else.